No way. Okay, good morning. We're going to call this meeting to order now. I'm Chair Kathy Lewis, and this is the Board of Appeals, the County of Hawaii. It's August 8th, 2025. Am I too loud? I feel like I'm too loud.
No, you're perfect.
Okay. The meeting is being held in person at the Kona Council Chambers and also virtually on the Zoom platform. So I'd like to just give a few ground rules and some reminders and things for people here and for people that might be participating on Zoom. All cameras, if you're on Zoom, all cameras must be turned on at all times during the hearing. So I guess no stealth participation there. Oh, and I also want to remind everybody to turn off the ringers on their telephones. One person should speak at a time, and I'd like to ask to try to abstain from side conversations. If you need to confer with your attorney, we'll give you a second. You can mute your device when you're not speaking to improve the audio quality and make sure we don't have leaking noises. If you want to be recognized, please raise your hand and wait for me to recognize you before speaking to make sure we have a clean and clear record. And prior to speaking, at least for the first time, please state your name so that all parties know who is speaking. And try to speak slowly, clearly, and be somewhat close to your microphone for the recording. Try to limit distractions with phones and other devices. And as a general reminder for Board of Appeals members, please state your name before speaking throughout our hearing today, which is a rule I don't usually follow. But I did introduce myself. My name is Kathy Lewis. You can call me all manner of things. Now is the time when we will take statements from the public on items on the agenda. Public testifiers can testify now, or if they prefer, prior to the agenda item they wish to testify on. Just have to let us know when and what, to what issue you want to speak. And Ms. Juan or Sylvia will keep time, and everyone is allowed 3 minutes. She will give you a 2.5-minute warning. Bethany, do we have any public testifiers at this time?
No public testifiers, Chair.
Okay, thank you. So there is no public testimony at this time, and we're going to move on to new business. Before I call the case, can I get the members of the board to introduce themselves? We can start on the left. John.
Board Member John Kimura.
Rachel Abel, board member.
I'm Kathy Lewis, chair.
Scott Martin, board member.
And for staff, I'll just note that we have Bethany Morrison and Ashley DeVera, and myself, Deputy Corporation Counsel Sylvia Juan, who is counsel for the Board of Appeals.
Okay, thanks everyone. All right, I'm going to call the first case number, which is our only hearing today. Aaron Gallagly, and the case number PL-BOA-2024-00000110. This is an appeal of the decision by the planning director dated July 2nd, 2024, regarding a closure letter for a notice of violation and order. And that is number PL-PCV-2024-00676, relating to unpermitted events, weddings, and the location of the dispute is at 75-5785 Pikake Place, Kailua Kona, 96740. Yeah. All right, Bethany, I'm going to ask you again if there's any public testifiers for this agenda item.
No public testifiers, Chair.
Thank you so much. All right, I'm going to ask, you want to do that?
Yeah.
All right.
Sorry, Chair, to interject here for a second. I just want to make a disclosure before we proceed with the hearing today. As a deputy corporation counsel, we do have a variety of different assignments. I'm assigned to this board, Board of Appeals. I'm also assigned to a number of other boards. I just want to disclose for the record that the landowner is a board member on one of the other boards that I also represent. And in that particular board and this particular board have nothing to do with each other, nor are there any matters that would otherwise conflict or overlap. So at this point in time, I do not believe that there would be any conflict or bias as far as maintaining my role in advising this particular board as far as their legal responsibilities and duties at this time. Thank you.
Thank you for that. Excuse me. All right, now Bethany, has appellant provided notice of hearing to the surrounding property owners pursuant to Rule 8-11D and proof of service filed?
Yes, Chair. The notice was filed July 11th, 2025.
Thank you so much. Okay, great. So as a preliminary matter, I'll note that after I have issued a I issued a pre-hearing order in this case granting appellant's request to withdraw one of the issues in her petition, so that accordingly the board will now consider only those facts as it relates to the alleged unpermitted event that occurred on April 19th, 2024. So with that, we'll proceed with the hearing. I'd like both sides to know that we have read the record in this case. So keeping that in mind, you don't need to repeat what you've already provided us unnecessarily. If either side begins to present testimony or evidence that is not relevant or is duplicative, I may interrupt you, I may stop you, I may limit you. Please don't take it personally. We just have a limited amount of time, and that's how we can keep things going. So there is one legal issue here before the board today, and that's whether the director's decision in question should be reversed or affirmed. And with that, we'll begin. The board will now hear opening statements from the parties. Please keep your statements to about 10 minutes. And when you have about 2 minutes left, Sylvia Juan will announce such, and we'll start with the appellant. And then the appellee will go. So that's you, Aaron. Little louder, hon. And as you may have guessed, anybody that's not involved, Erin is here without counsel, so we may be coaching her a little now and then if she needs. Go right ahead.
Aloha, good morning. I first just wanted to start, I want to give this to you, Jason. This is actually a prayer card that some of his missionary sisters gave to me back in July of 2024. And I have sincerely been praying for Jason and this whole thing. So that's sincere. And I actually told your missionary sisters that that I was going to give it to him. The other thing is I want to thank Jason. I know this sounds really weird, but over the past couple of months, it appears that these musicians have been gathering at the Kona Retreat Center, and the door must be closed because you can hear this talking and music and clapping, but it's really muffled. And there's traffic, but these local style kind of kapili sessions are very respectful. And now, don't get me wrong, there have been other gatherings with amplified music, but in this case, I really appreciate the musicians and Jason being Pono. So thank you. I filed the appeal as the director's decision is clearly erroneous due to the fact he was not provided reliable, probative, and substantial evidence from the landowner to rebut the evidence provided by the 4 complainants. The director did not have sufficient reliable information on which to base his decision. The credibility of the information does not appear to have been questioned. I request his decision be overturned and a new closure letter issued stating the unpermitted commercial activity did occur on April 19th, 2024. So something about myself, I'm a retired soldier, and for the majority of my 28-year Army career, I served in intelligence and planning. We gathered information, presented facts and assumptions, developed courses of action, and provided recommendations on which our commanders made decisions. It's a very detailed process called the military decision-making process. So it's unclear how the evidence that was provided by the landowner led the director to conclude that no commercial activity occurred on April 19th, and that the evidence provided by the 4 complainants was categorized as allegations. And given that the director has discretion to determine the sufficiency of the evidence presented, his decision was erroneous, as he mistook an undated document with inaccurate information as evidence, vice these timestamp videos and statements from the 4 witnesses who filed separate complaints. As stated in the county's legal memorandum dated August 1st, the director's decision to pursue enforcement of a violation should be based on reliable, probative, and substantial evidence. Or stated in another way, enforcement should be based on accurate, valid, tangible evidence, and the credibility of the witnesses should be evaluated. The documents provided by Jason to substantiate no commercial activity occurred on that date, April 19th, is vague, lacks dates, lacks verifiable information, and frankly is filled with some hyperbole. So going back to my military decision-making process analogy, analysts and planners, we look at historical events to determine what happened, and then we assess the reliability of that data, the credibility of the people and systems that provided the data, the past assessments we made to see what we predicted, did it really happen? Then afterwards, we conduct after-action reviews to adjust and incorporate lessons learned. And I'm assuming that the planning inspectors and the director have some similar process. When Nick and I were at the annual Hakalau Forest hike, we look at a bird, and then we see and hear how it waddles, it quacks, it flies, and then we assess it's a Hawaiian duck because it looks, sounds, and acts like a duck. We don't call it a penguin or an eagle, even though the duck may have similar characteristics. During this hearing, we'll talk about what we and Jason saw and heard on April 19th. Then I'm assuming you can then discuss, did the director have sufficient, reliable, probative, and substantial evidence provided by credible witnesses to determine if the director's decision was erroneous? Mahalo. Thank you.
Good morning, Chair Lewis and board members. I am Jean Campbell, Deputy Corporation Counsel representing the Planning Department today, and with me is Planning Director Jeffrey Darren. We thank you for the opportunity to speak with you this morning. The matter before you is a simple one, which turns on questions regarding the sufficiency of evidence and the Planning Director's scope of authority. The appellant is asking you to reverse the director's closure of a notice of violation, which alleged that an event that took place on April 19th was a commercial event, which would in fact not be permitted on this property. The appellant appears to believe that the landowner did not present sufficient evidence to the Planning Department to prove that the event was not a commercial event. As is the case, anytime the government accuses someone of wrongdoing, the government first must prove that the wrongful action took place. It's not the alleged wrongdoer's burden to prove that they didn't do it. So it's the director's duty to determine that he has sufficiently reliable, probative, and substantial evidence to support a finding that a commercial event actually took place. The allegations in the various neighbors' complaints that a lot of cars came to the property, some of the people were wearing particular attire, and the gathering was noisy, are simply not sufficient evidence to establish that this event was commercial in nature. The director will discuss. The director does.
I'll just note that I'm pausing time while we deal with this technical difficulty, so you can fix that.
Okay. I'm good. Okay, I think we're good.
Okay.
All right. The director will discuss the evidence that he looks for and what he had in this case. With that, you will see that he simply did not have sufficient evidence to prove that this event was commercial in nature, and pursuing the notice of violation based only on the statements of the neighbors would have been an abuse of the director's discretion. The other complaints were about noise. Much as we might like to, the county does not regulate noise. That's the job of the State Department of Health. Any attempt by the director to enforce state noise regulations would again be an abuse of discretion. Because the director had insufficient evidence of a commercial event and no authority to enforce noise regulations, he properly closed this NOV. We ask that you find that this closure did not violate the law, was not clearly erroneous, and was not arbitrary or capricious, characterized by an abuse of discretion, or a clearly unwarranted exercise of discretion. So the director's closure letter should be upheld. Thank you.
Thank you.
Can you hear me now? Good morning. My name is Patrick Wong, and I represent Konakai LLC, the landowner. Mr. Jason Isert is a managing member of Konakai LLC. We ask you to affirm the director's decision that there was no violation.
Can you be a little louder?
That there was no violation of the code, and there's no commercial activity that occurred on the property. The evidence will show that there was a wedding that occurred at the outrigger that was paid for by the tenants that occupied Konakai's property. The documents already submitted to you, and I understand you have reviewed, verifies that the commercial activity occurred at the outrigger, not at the residence. They were simply housed there. And music and or parties and or loud noises, I agree with the Deputy Corporation Counsel. It's within the guise of the Health Department, and the ordinance that deals with noise enforcement falls under the Police Department, not the Planning Department. What you heard earlier is a reference to 4 complaints. What you have before you is limited to one day, April 19, 2024, one complaint that there was commercial activity and that there was noise. You should disregard the noise complaints because there's no police report that verifies it, and it's beyond the scope of your jurisdiction and the planning directors. And when you focus on the one contention of commercial activity, there's evidence before you that establishes that the commercial activity of the wedding occurred at the outrigger, did not occur at the residence. With that said, you should affirm the director and dispense with this as soon as possible. Thank you.
Okay, thank you for your opening statements. And now, Aaron, you can call your first witness and she'll be sworn in by Ms. Wong, he or she, or,
So my first witness is going to be Jason.
okay?
And
Where
I'm
do you-
gonna walk over.
You want him to just
and
stay
hand him
there?
these if this is okay. I'm handing him.
So
Wait a minute.
At
Tell
this-
me what you're doing first before you do it. What are you intending to do?
So I'm just giving him, exhibit J. So he has it.
Okay, well, you just tell us that, in order to get exhibits into the record, when it's time for you to do it, then you'll let us know
Oh.
what you're handing him and
Okay. the
so
first
forth.
one, I'm
So
just
I'm sorry, Miss Aaron. First things first. I need to thank you, Miss Campbell. We do need to share mics today. I'm sorry, we do not have enough mics to go around. Thank you, Miss Campbell, for giving the mic to the to-be witness. Because you're going to be a witness, can you please stand, not stand, but sit at this table separate? This is the witness table. And at this time, is your mic on? Great. If you can, please state your name for the record.
Sure. My name is Jason Isert. I'm the landowner for Konakai.
Thank you. If you can, please raise your right hand. Do you swear, affirm, and attest that you will tell the truth and nothing but the truth to the board today?
I do.
Thank you. Now, Miss Aaron, you may continue with your presentation and your questioning of this witness.
So I was going to hand him, parts of
You
exhibit.
can go ahead
J.
and stand and do that and
And
carry on.
do I do them all at once? Because I'm gonna be asking him
I-
questions about different pages.
If you want to put a pile near him so it's convenient for you, that's fine.
So I'm gonna be giving him pages, 4, this is exhibit J.
But just do each one as you go, as you're using them and questioning them, let us know.
So this is exhibit J, but then the pages. So Jason, does the Kona Retreat Center offer commercial activities?
I'm going to object this to the form of the question is calling for a legal conclusion on what commercial
Oh,
activity is.
first of all, what was this question again?
Does the Kona Retreat Center offer commercial activities?
Okay, is the Kona Retreat Center a party in this?
Well, it's the building, that's what he calls it online. It's,
Okay, why don't you establish that first?
okay, so Jason, the.
I'm gonna overrule the objection for now and see where this is going. Go ahead.
So the Kona Kai, I think it's LLC. My understanding, or you tell me, is the Kona Retreat Center, the 10,000 square foot mansion. Is that part of the Kona Kai LLC?
The property is not called the Kona Retreat Center. I don't know that I've ever called it the Kona Retreat Center. The name for the estate is the Kailua Kona Estate, and it's
Oh.
also not 10,000 square feet.
Yeah, I think it's like.
What was the name you said?
It's called the Kailua Kona Estate.
Okay,
So we're gonna call it the Kailua Kona Estate. And I think, Jason, it's like 9,700 feet, something like that.
I would defer to the real property tax office for that information.
Okay. Well, it's somewhere around 9,700 square feet based on the tax record that was in, but that.
well, we'll let the record take a look at that, but go ahead and ask questions, okay?
So does the Kailua Kona Estate offer commercial activities?
Same objection, calls for a legal conclusion on what commercial activity is.
Okay, I'll sustain that. Why don't you ask it more piecemeal?
Okay, sure. So can we refer to Exhibit J, page 4? So on that Exhibit 4, it says,
Establish the foundation for that. Find out what it is, who made it, that kind of thing.
okay, so this is screenshots that you can see.
So ask him
Oh,
to establish the foundation for that exhibit.
okay. Well, this is my exhibit, but Jason, is this a representation of the Airbnb link for the luxury Kona mansion?
I would need to check, but I believe so.
Okay. So, and that's the link up there when I pulled it in July.
I'm going to stop you for a second because I think you're calling, we've got now 3 different names for this property going around. Is there a reason why you're making these distinctions?
Well, on the, he's got Airbnb, VRBO, Booking.com, and then he has another website.
Okay, I think to keep things simple, let's just call it Kona Kai from now on.
Okay.
Understood.
So this exhibit I pulled from Airbnb, and you said this was a representation of the Kona Kai property. And so I'm just reading, or maybe he should read what it says on here, and that's what I'm going to use these couple of pages that I pulled. So it says on here, if you need assistance booking excursions, private chef, in-home services, or rent-a-cars, please reach out. So my question is, what is an in-home service?
It really depends on the guest and who comes to the property. Oftentimes there are guests that are coming that have never traveled to Hawaii before, and they're looking for different activities and things to do. And so in an effort to provide the most service that I can as a host for this Airbnb, I have built up a list of recommendations for different excursions, private chefs, in-home services, and the like to refer to those guests, although I don't make money on it, simply to offer the best kind of service that I can. So
Okay, I'm going to stop you, Jason. Try not to let your answers go on and on and on because we've got to keep things fairly succinct. She'll ask you a question, focus on that question, you answer the question, then you ask another question, okay? It's not like a conversation where you just kind of go from one thought to another.
sure, okay. In-home services could be things like occasionally, because this is a higher end property, the guests will ask to have the property cleaned during their stay. And so having cleaners come in to touch up the bedrooms or clean the kitchen or things like that. Yeah.
And then the private chefs.
Yep. So private chefs, there's a number of different private chefs that guests can hire. So sometimes they get it catered from places like Umeke's, or recommend them to a private chef. I'm not sure, what's the question?
Oh, no, I'm just asking, so you're saying the guests hire the private chefs?
Yeah, I never hired. Correct, the guests only hire the private chef.
And the rent-a-cars, do you offer rent-a-cars?
Kona Kai does not own any rental cars now.
So you don't have a Turo business on your property that you rent Turo vehicles?
I'm not sure I understand.
So,
Do you know what Turo is, Jason?
I do know what Turo is, yes.
so do you have Turo vehicles that you rent to guests?
I do have a separate, completely separate company that has rental cars, yes. But no, it is not affiliated with this at all, except for that I give them a link to book the vehicles when they want to come and stay at the property. I'm not sure I understand the relevance of that.
If that's not your place to decide that, Jason, just answer the question you're asked.
Yeah, Kona Kai does not own any Turo vehicles.
That wasn't the question you were asked, but nonetheless, that's fine. Go on to
So
the
I
next
just want to
question.
clarify, you have a separate company for Turo, and then you advertise rent-a-cars, and then people get the rent-a-cars from you, but they're not affiliated with Kona Kai.
And they do not get them from our property.
Okay, but you deliver them to the airport maybe, or?
None of it's.
Okay, I'm gonna stop that line of questioning because it's not relevant to that date. Let's hone in on the one
So let's
day
see,
and-
page 25, and this is, I'm trying to just get there. So on 25, it lists there restaurants. There are 2 restaurants on site. So I'm on J25.
Okay, what's the question?
I'm just trying to confirm you have 2 restaurants on site.
No, I do not have 2 restaurants on site.
And then these amenities that are on site at the Kona Estate. It has on here spa, personal trainer, yoga, transportation, car rental, a beauty salon.
We don't offer any of those things. This was made by booking.com, and they make their own listings, and I don't have any control over the listing because they create that themselves.
Okay, so even though Airbnb has this out here under amenities of the Kona Kai, these appear to be commercial activities.
I'm going to object this to the relevance and focus on whether or not any of this is relevant to what occurred. on
I think
April
we're moving
19th.
on. I don't think I need to rule on that right now. We'll just let her go ahead I think we're getting through this.
And the reason I ask is, so down at the bottom, activities, it has these activities that are additional charge off-site. So if the guest is snorkeling,
I'd like to reiterate Mr. Wong's objection.
I do understand.
To
Right,
point detection.
right.
Whether they snorkeled some other time, whether they rented a car, none of that has anything to do.
Correct.
with this.
I agree with her on that, and I will sustain that objection. But
okay, what I'm trying to get to is if there are 2 restaurants on site.
I think we know what you're doing. I do understand the point you're making. I think we all do. So we'll move on now.
And could I just ask,
Can I finish?
Jason, hold on. Just let her finish the question.
may I just ask, are these amenities part of the rental agreement?
Again, I didn't create this here, so it's,
All right, I'm just trying to figure out if they're part of the rental agreement,
no, they're
or do you charge separately for these amenities?
Same objection.
Right.
Also calls for
not.
speculation. There's no foundation as to any of what she's saying occurred on April
I
19th.
think she's finding out now what's going on. Without discovery, it's a little hard. So we got to give a little leeway, but I think you're understanding the setup now, and we do. So let's move on.
How many guests can stay at the Kona Estate?
There's a couple different occupancies that we can meet. It's either 1 family and 4 unrelated people or 5 unrelated persons.
No, what's the max number of people who can stay?
That is the occupancy limit.
What is it? I couldn't hear you.
One family and 4 unrelated persons or 5 unrelated persons.
So if I have 50 people in my family, can I have 54 people staying there?
Objection, improper
Let
hypothetical.
him answer. I'll overrule. Go ahead.
Because the definition of family, he's
Just
exactly
go
right.
ahead and answer it, Jason.
I would not allow 54 people to stay at the estate, no.
So what is the max number of people who could stay at the estate? A family plus 4, what is that number?
There's a lot of different families. There is no number that I could give to you.
Okay, I would assume it would be limited by the number of bedrooms or beds.
And how is this relevant to April
I
19th?
don't know, but let's have a little leeway, okay? Go ahead.
So
Finish
50
that
is a
line.
no-go, but would it be 40? I'm just trying to get to.
Objection, argumentative.
Because,
Noted. Overrule.
I've already answered your question.
okay, would you allow 40 people to stay there?
Same objection.
Overruled. Go ahead and answer.
I would likely not allow 40 people to stay at my home now.
So how about 30 people,
Most likely no.
22 people?
That's closer to the range of what we'd be able to accommodate.
Right, okay. And the reason I'm saying that is it's advertised as 6 bedrooms, sometimes 7 bedrooms.
That's incorrect.
How many is it advertised for?
There are 5 bedrooms in the home.
Okay. So I think, may we go back to page 4 of Exhibit J? What does it say for the number of bedrooms?
Okay, I think we're belaboring this point. We've got to get moving into the day in question here pretty quick.
It says 6 bedrooms is what I read. And so we're gonna go with 22 people because somewhere in one of these it says.
We're not going with anything. We're just waiting for you to ask a question.
How many guests booked for that reservation on April 19th, 2024?
I don't remember.
Okay. And were they charged the normal rate, the normal nightly rate?
Can you clarify what you mean by that?
Well, so if on your website, when you click, there's a daily rate of, let's say, $1,000.
Okay.
Did they pay, because I'm just like, the people who booked for April 23rd to the 26th, which we're not talking about, I'm just trying to say that was 4 days, 3 nights. Whatever they paid for the nightly rate, did the folks that were staying there on the 19th, did they pay this about the same rate?
I would need to check, but I use the pricing software that determines the nightly price because it's very seasonal out here.
Okay.
And so they paid whatever that rate was. For
Right,
that
so
night.
they weren't charged any up fee for any of these amenities that were listed.
Again, I am not aware that these amenities listed are from booking.com and
Okay.
I did not create this.
Okay. Can we please refer to Exhibit A? And here it is. So page 2, are those our text messages?
I believe this is a text message between the group, myself, you, and Nick.
Okay. And on here, you say,
Ask a question.
can you tell me, what did the guests respond to you when you said you texted them? What did those guests respond to you?
That they would turn the sound down.
Okay. And did you come to our home on that night, April 19th?
I don't know the exact time. I don't think it was the night per se, but it was in the late afternoon, evening time. Yes.
So it was about 8:15, 8:20, and I'm saying that because I just want you to look at the text message. The timestamp is 20:04, which is 8:04 p.m. They responded to my text and said they would keep it down as it better now.
Mm-hmm.
And you and I talked on the phone, and then you came to our home. Do you remember being at the home talking to Nick?
I didn't come into your home. We were standing
No.
on the road.
Yeah, were you standing on the road or in the carport?
Let's get to some relevant evidence
Yeah, I'm
about the
trying to-
commercial activity.
Yeah. So my recollection is you were standing in the carport, and what did you hear?
From my property or
From our property, what did you hear coming from your property?
light music.
Okay, and how would you describe that music? And I understand the planning department,
So why are we doing this then?
because I'm trying to get to the point of this noise, what it's indicating.
Can
How would you
I think the
categorize
parties
that?
have all admitted and stipulated that there was noise. And the noise is not the issue before the
Right.
board.
Well, did you go up after you left Nick and you all talked about the noise? Did you go up to the property,
I went back to my home.
which is, your home is next to the Kona estate that was being rented?
It's on the property.
It's on the property. Okay, so on one of yours, it says that you, one of your rules is that the parties, you can go into the property if there's a complaint. So we. can
Okay,
come to
all
you.
right, Aaron,
Did you go
Aaron,
inside?
Aaron,
Yes, ma'am.
it sounds like you're working on the noise situation here.
All I'm just trying to show is when he went to the property, meaning where the party was happening, what did he see there?
You need to be establishing a commercial activity related to it and not belabor the noise. You don't have that much time.
Okay, well, what I'm trying to say is when he showed up, what did he see? He saw an MC, he saw speakers. he
Okay,
saw
ask
people.
him questions and be sure and link it.
Okay.
If that,
So-
just ask questions.
Okay.
You know,
When you went to did you go and physically see the party that was happening?
I sent them a text.
Okay, so you
And I did
physically
not go
didn't
inside
go
at
there.
all.
You didn't go, even though you had received a complaint from us? Because, okay, it just appears that there was a wedding reception that was occurring.
Is there a question?
Yeah, I'm asking you, what happened? The guests that were staying there, they had their wedding there earlier that day.
Objection, assumes
That's incorrect.
facts not in evidence.
Oh, well, it is. It's actually in the clarification of the closure letter. It says that it was, which is page, I think 50.
we can argue that at closing arguments, okay? I want you to ask him some succinct questions and get this moving, okay? You're trying to argue and give evidence rather than asking him questions. And
Okay.
we can't
Can
keep
we-
doing this.
Can we just go to the index, page 55, which is the clarification of the closing letter? And it says, the party staying at the property did have a wedding at the outrigger earlier that day.
We've established that.
Okay. so
We've
they had their
all
wedding
stipulated to
ceremony.
that.
They had their wedding ceremony there. I'm arguing this was a wedding reception.
This is not
was
the place for an argument right now.
Okay.
You need to establish the facts that will support your argument.
Okay, so what I'm trying to get at is who hired
There we go.
thank you. Who hired the MC?
I don't know that there was an MC there.
Should I play a video or you all have heard the video? I don't know if we can play it.
I want Jason to answer the question.
Yeah, I don't know that there was an MC there.
That's not the question. Did you hire the MC?
I did not hire an MC. No.
Did you give them information on to hire people? So when they contacted you for these in-home services, did they ask you, we need an MC, we need a DJ, we need a chef? Did you provide any of those contact information to those folks?
I may have provided a chef, but I've never referred an MC or a DJ to any guests that have stayed at my property.
And okay, is one of the in-home services, do you provide speakers? Because in one of your rules, it says no speakers, no boom boxes. Do you provide speakers, karaoke machines?
I do not.
Have you ever given that as an in-home service? Saying,
Not.
so you don't have a list that says, here are services for, how do you say, sound, DJ, karaoke machines? You
He's
do not-
been asked and answered those questions and he's,
Okay, wait, let me listen.
I said he's been asked and answered,
Yeah,
time and
right,
again.
you don't need to keep asking him. You're gonna have to
All right, so
let
you
him
give
answer it.
information for a private chef.
I may have, I don't recall if I did or did not, but that is something that I have done for guests, yes.
Did you hang up lights on your property for those guests? String lights?
How is string lights relevant to
There you
commercial?
go.
activity?
That's sustained. That objection is sustained.
Okay. All I'm trying to get to is you. gave
Now,
them-
wait till your
Oh.
argument for that.
Okay. Do you have any, the noise summaries that were asked in the subpoena? Do you have any of those noise summaries? Or are we all gonna agree there was amplified music coming from your house on that day?
Am I supposed to choose one or the other?
Okay,
Well,
okay. well, I
it
guess the
seems like
question
it
is,
has been
has been established
agreed
that there was
that
amplified
there was music, yes. What
DJ.
you need to show is that that's somehow linked to a commercial act.
I don't believe there was a DJ there.
Okay, or an MC, okay, so you never gave them, I just want to clarify, you only gave a private chef, you didn't give any sound type of.
Asked and
private
answered.
purposes.
I'm gonna sustain that objection.
Okay, he doesn't remember.
Well, not only that,
Argumentative.
he's already testified that he didn't charge for those referrals, so it's just irrelevant at this
Okay,
point.
right. And then you did not go into the house, even though we had complained, you did not go into the
It's
house.
been asked and answered. He's already testified to that.
No, sustained,
So you didn't go to the house, I just.
Same
Sustained.
objection. Move on.
sustained
Um,
objection.
Can we go to the landowners exhibit D?
You have it.
I do not have, I don't believe it.
Do you know how many people were there that night?
Again, I didn't go into the property and I did not count the people, no.
What is that?
So on that. So on the page 49, it says, on-site parties and group events are strictly prohibited. Were they having an on-site party or a group event that night?
I don't believe so.
Okay.
I'm not sure what. Yeah, I don't believe so.
Okay. And if we can go above that, it says, each unauthorized, undeclared person entering the property will result in a charge of 100. So we had made this complaint. Use on your rental agreements, they have to list who's there, correct?
This, I can't recall how this gets booked, but no, they don't list every single person.
Okay, so you wouldn't know then, if they didn't, you wouldn't know who was unauthorized or undeclared because they didn't list their guests.
Yeah, this is a personal rule that I created, just in the case that, yeah, that's correct.
Okay. And so for the subpoenas with the traffic, do you have any of that summary? That's for the subpoena?
So for the subpoena, number one was, I believe, unedited 24-hour footage from between two times, the 19th to the 20th. And my cameras don't record back that far, so I did have that for probably up to about 6 months after the incident, and then my cameras overrode the footage, so I no longer have it.
Okay. But you did say to the planning department that you had videos and noise summaries that you could have given them. You offered that to the.
At the time, I did have them, yes.
You did, okay, but you don't have them now.
Yeah, the cameras don't
Okay.
store that much.
All right. Can we go to the index, page 30, which I believe is your exhibit E? So the landowners exhibit E or the index. Index page 31. So this is a letter from the landowner. And that landowner she said, I'm gonna read it if that's okay, and then ask a question. In the second paragraph, I was clearly informed by Jason when we booked that we couldn't have the wedding or an event at his property. So when she booked, she signed something similar to.
All right, I'm going to stop you, Aaron, because you're not proving the issue. I know,
I'm just trying to call.
do you have any other witnesses, by the way? Do you have witnesses? Okay, because your time is running very low.
I'm just trying to establish that she and Jason agreed the wedding was at the Outrigger earlier that day.
This is not a lawsuit or a dispute between, Jason and his renter or you and this is the county that you've brought before us here.
Yeah, I'm just saying he provided pages 31 and 32 to the county as evidence.
Okay.
And what I'm saying is that her letter that I'm just referring to as her, but this bride wrote this letter, but she says on the dates in question. So she doesn't even put April 19th. She admits that she couldn't have any events.
Okay.
But it appeared there was
So
music and
he didn't write the letter. She did.
Oh, right, but he submitted it as evidence, so
Okay.
I'm just asking. Then she mentions about personal photos. Were personal photos mentioned in the complaint for April 19th?
Aaron, I'm gonna disallow that's just,
Okay.
you're going down avenues that aren't relevant to the commercial activity you need to establish.
Say that she must have received these in-home service references. And then she, an off-island person, called all these in-service.
Not relevant. Okay?
So,
If
okay, so
you
those
want to
are-
argue that, you can, but let's
Okay.
ask him some questions, establish some facts, and then get to your next witness.
All right, well, I just want to clarify, you provided her no services other than she stayed at the home.
Ask it as a question.
Did you provide any services to this guest other than the building in which they slept? And the building in which they had some sort of gathering with really loud music?
Did I provide any services? I mean, I like to think that I provide a lot of services for my guests when they stay, be that a quick response when they have a question for me, or a clean home when they show up to the property. So I do believe I provided them service.
So any in-home services? So did you gave them the name of a chef? And they paid for the chef?
Again, I've already answered that.
If he did that.
I'm just trying to confirm that you didn't provide them any additional activities other than the phone number for the private chef?
It would have been more than just a phone number. It would have been a phone
The
number,
contact
their
information.
name, and maybe a little bit about what
Okay, but-
they could.
Okay,
Yeah.
so I guess no one.
Don't
you didn't
guess,
provide-
don't guess,
Okay.
just ask him a question.
All right, so, and I just want to clarify, you did not go to the main house and I just want to confirm that, and I want to confirm also that because we made a complaint, you never intervened with them face to face, other than the one text message you sent to them to ask them to quiet down. So I guess.
Sorry, I don't know what the.
I just want to confirm, you did not go to the main house to talk to them in person.
If he's
Okay.
already testified to that, you don't get to keep
Okay.
asking him the same question.
Well, may I review my questions just to see?
Okay.
Thank you. And did you only have that one text message? I just can't remember, that one text message back and forth, you and your guests, please quiet down. And they were,
I only have one text message with the guest. I texted
on that, on April 19th at about 7:43 PM.
Did I have one text message with them?
Well, that's what you said in the
I-
text message to us.
I did, yeah, I did text them and ask them to turn it down, and they did.
Okay,
That's correct.
okay, and you don't have any noise summaries either that was in the subpoena?
Do have the noise summary.
Oh, you do? Oh, great, okay. Is there a high and low?
There's not.
So what's in the noise summary?
I'm gonna,
Okay, all right, we'll just admit that there was noise. And you said you talked to my husband, you talked with mom. Okay, so I think that's it.
okay,
Thank you, and I appreciate your patience.
sure.
Thank
Yeah.
you.
Ms. Campbell, you want to cross-examine?
Thank you. The county doesn't have any questions for Mr. Heiser.
How about you?
Chair, I'd like to submit the noise report and I'll just read it for the record.
Okay,
It says, noise log for period,
can you speak a little louder?
noise
Or closer?
log, April 19th, 2024, 3 PM to April 20, 2024, 3 PM. No sustained noise detected.
I did print out a copy for everyone if you want to distribute that.
That's all right. It's irrelevant.
Yeah.
Okay. Do you have any, you want to, well, no, I guess, never mind.
I have no question for Mr. Heiser. Jason, you can.
You could
stand.
call him in if later if you like.
Okay.
Okay. Aaron, you can call your next witness, and then Jason, you're excused. Thank you very much.
Thank you so much.
May I call Cynthia Milani? She's our neighbor. This is Cynthia. You know what, Jason, do you mind just leaving them there? Okay, thank you. So, may I?
Okay, she can come over and be sworn in.
Oh,
Sorry. And she'll need a microphone. Oh, there it is. Okay, good.
So once you're settled, if you can, please just see if your mic is on. Okay, if you can, please try to turn it on. Now test.
Test.
Great. Can you please state your name for the record?
My name is Cynthia Milan.
Thank you. And if you can, raise your right hand. Do you swear, affirm, or attest that you will tell the truth and nothing but the truth to the board today?
I do.
Thank you very much. You may proceed with your questions.
Before we do, how much time do we have left on her case?
So how much time are you trying to say? She has half
About a half hour.
Okay. She has about 10 minutes left on her case.
Okay, so. No, I just wanted you to know. I don't know what you have planned for today, but so. I'm just letting you know, you've got about 10 minutes for the rest of your thing.
so if I'm not sure how to pull this up, but I see, Cynthia brought a picture of exhibit, A, and I'm just gonna try to pull up the picture. How long have you lived next to Jason?
5 years.
Okay, and the picture, if we could go to exhibit A, page 2. Oh, I'm sorry. We need to go to a video, but, and I'm sorry, I don't know how to do that on here, but, oh, here it is. So this picture that's on the video, this is the 20A, and it's the 23-second video. What is this? Do you know?
Well, this is one that was taken from my house and there's all these extra lights and we're wondering why there were so many lights the night before.
Okay, and have you ever seen any of that on the house before?
No.
Okay, never, is it still there?
No,
Okay, and when you made a complaint also, what did you hear?
I had out-of-state company and we were outside, my dining room is outside and we could not talk because there was someone on a microphone talking and people yelling and screaming and loud music. So there's definitely a party reception going on there.
Okay, and was there, so it was amplified noise?
Yes.
And did it sound like a small family gathering
No.
or, okay, what do you, big family?
No, there are a lot of parties there and we usually up this after 9 o'clock, call Jason and ask him, could you please turn it down so we don't have to call the police? This was one that was pretty much like 7 years ago when that place was first open and they had a big party and the whole neighborhood rattled because of their speakers.
An objection as to time and space. It's not relevant what occurred in the past.
Sorry.
Well,
No, that's okay. Did you call, text, communicate with Jason that night about the noise?
No, I had company and so we moved inside and continued our dinner.
Okay, all right. So you saw those lights that you'd never seen
Yes.
before? Okay. And you heard a lot of noise?
Yes.
Okay, that's good. Thank you.
Okay, any cross-examination?
Hi, I'm Deputy Corporation Counsel Jean Campbell. In your mind, what specific factors for you as an observer of a gathering at a home differentiate a loud, noisy party that we're all allowed to do and actual commercial activity? How can you tell the difference from outside?
The noise. Those have amplifiers. I mean, why would you have a small party and you have someone speaking on a microphone? I don't understand that. I mean, I have parties, but it's nothing like this. And we've asked him to please. Jason and I were friends until I caught him in so many lies that I'm.
Objection, move to strike, not relevant.
I didn't hear it, but it's sustained. Just answer the question
Yes.
as best you can.
No further questions.
Okay. How about you? Christy? Any questions? No cross-examination? All right, you're excused. Thank you. All right. Do you have any other witnesses?
Four and a half.
How many?
4.5.
May I just ask Should I just ask a question? I was gonna call my husband Nick and I was gonna go through this video of the amount of traffic that was going up into Jason's. May I show that or?
You have how much time?
Minutes.
You have about 5 minutes.
Okay.
You can use it however you like.
Okay, well then I'll call the planning department.
Okay, you know you can cross-examine the planning department when they call him, so you don't
Oh,
have to
so
use your
we can
case in
use
chief
that.
on him.
Oh, okay, because I thought okay.
So you'd still have your 5 minutes, so
Okay, then may I call Nick
you could
and
go.
he's on Zoom
Okay,
and.
Hello, this is the Board of Appeals. If you can, please unmute your mic.
Can you hear me now?
It appears that you're in a vehicle. Are you in a parked, safe place?
Not just yet, but I am free. Were you able to hear that?
well, I don't think it's a good idea for him to be driving and testifying, no. So let's have him pull over.
So Nick, can
Yeah, is it possible for you to pull over shortly?
It'll take me probably 3 or 4 minutes. I have to get around the corner before I can find a place to pull over.
Okay.
and you know what?
What?
Nick is on his way for cancer treatment and he has to be there at 11 o'clock. They specifically moved his time, but he has to be there at 11 o'clock. So, I'd rather not have him pull over. I'd rather have him go to his appointment,
Okay,
if that's okay. So
okay.
Okay, so,
this video,
sure.
Go ahead.
So, Mr. Nick, you can go ahead and mute your mic and turn off your video. It appears that Miss Erin has decided to use her time in a different fashion. Thank you.
You have 4 minutes. You can show us a video. It's an exhibit of some sort, right?
Yes.
Yeah.
it's Exhibit G. And what this video we're showing was over a 25-minute period. There were 12.
So, if you are on your Zoom, you can share screen.
You want to go help her?
I'm so sorry, I've never shared my screen before.
Bethany's going to come assist you.
Oh, I thought she got.
So while she's doing it, can I just talk to what it is?
Just very quickly introduce it. Yeah. Like,
So
give us a
what
back.
this is it's a video that was taken.
By whom? Who
pardon?
took the video?
This is video from our house cameras.
Okay.
And I believe there's 2 cameras, so sometimes you're gonna see the vehicles twice because,
That's fine.
And so what Nick did is he took this video and it was taken from approximately 5:55 PM to 6:25 PM. So about 25 minutes, or whatever the public math is for 25 minutes. And there were 12 vehicles that went by filled with people. Each one had at least 2, if and most had 4. And so in this quick, short time, we're traveling up to Jason's party. And there were already people that were there from earlier.
So how long is the video you're going to
It's
show?
1 minute.
Oh, okay. All right.
So all I was just trying to show in this video is that this wasn't a small family gathering. This was a wedding reception with commercial activity. That this wasn't a little party.
Gotcha. Let's see that video if we can.
She's there. I'm sorry? Can you see the video playing? No. Oh, she got off.
So what this video shows, that we made it 2 times speed. This is what Nick's sent to me. It's double speed of 12 vehicles: a black car, a black truck, a silver blue van, a gray van, a black truck, a silver car, a black Jeep, white car, silver Jeep, white van, silver car, white van. So there were 4 cars, 2 trucks with the, extended cab, 2 Jeeps and 4 vans for a total of 12 vehicles that went up into Jason's lower entrance, we call it.
Okay.
In that 25 minutes. So I don't know if we can just turn my screen to them.
Mhm.
It's a 1-minute video and it's just of these 12 vehicles. And
Is it playing?
Pardon me?
Is it playing?
Oh, yeah, see, this is in the way. I don't know how to move.
Okay, we're gonna just, I think, take your word for that and
Yeah.
move on.
Okay.
I will just note for the record that the board, each board member does have access to all of the exhibits that have been filed in this case.
Okay, so that would be exhibit G.
Okay. Sorry, that didn't work out for you. Okay. Do you have anything further in your case in chief yet? No further witness? Okay. All right, thank you. We'll move on now to the department and let Ms. Campbell get started.
Good morning again. I would like to call our planning director, Jeffrey Taylor.
Excuse me. I'm going to just mention to you, Aaron, the way this works is that he will be asked questions by his counsel. You can interject objections if you have any, but then you cross-examine him about the things he spoke about. All right?
Good morning. We'll just give you a moment to set up.
Everybody doing okay? I think we don't need a break.
Okay. Do you need a reason?
Everybody okay? You need a break? Okay. All right.
Chair, it does appear that one board member would like a short recess.
Oh, okay.
If
We're going to take a quick 5-minute break for bathroom purposes and so forth.
and then in the meantime, you can set up.
Yeah, we got time. I'll wait for you, right?
Yep.
Are you ready, Ashley? Yeah. We're ready?
Oh, you are? Oh, I'm sorry. I thought it was with you. Yeah, okay. All right, we're reconvening and we'll start now then with your presentation, Ms. Campbell.
So I'll just note for the record that just before the break, Ms. Campbell did call for the department planning director, Jeff Darrow. At this point in time, I will note for the record, he is sitting in the witness box. If you can, please test your mic. Great. Can you please state your name and position for the record?
Good morning, Chair Lewis, members of the Board of Appeals. My name is Jeff Darrow with the Planning Department.
Thank you. And can you please raise your right hand? Do you swear, affirm, or attest that you will otherwise tell the truth today before the board and nothing but the truth?
Do.
Thank you.
Good morning, Director Darrow. I have just a handful of questions for you. So when the department is trying to determine whether an event that took place in a home is commercial in nature, what kind of evidence do you generally look for to determine whether it was a commercial event or simply a private party?
Typically, when it comes to being identified as a commercial event, we look for evidence that there's been some sort of advertising for an event that's commercial, an exchange of monies for that event, whether it's through ticket purchase, or even sometimes people will say they're taking donations. That's typically how we can identify a commercial event.
Thank you. In this particular case, what kind of evidence did you have to evaluate whether or not this was a commercial event or simply a private party?
There was evidence submitted from the complainant that was evaluated originally, and then subsequently there was information provided by the landowner to be able to assess and make a determination.
Thank you. So the evidence that was originally submitted, do you recall what the complaints said? What kind of allegations were in the complaints to help you to establish that this might have been commercial activity?
The complaint said that there was a loud party, that it was very noisy, there was a lot of traffic, and there were people in a particular type of attire.
Okay, thanks so much. Based on the planning department's current procedures for evaluating complaints like this, would the department have issued an NOV?
Can you repeat that, please?
So based on I understand that the planning department has changed your procedures since 2024. So based on today's procedures, would the planning department have issued an NOV based on the evidence that you had in this case?
Thank you for the question and for repeating. So since this time, and approximately about this time actually, the planning department had received responses to our issuing of notice of violations, mainly from the people receiving them, because it did not give them an opportunity to be able to provide information on their behalf before the planning department issued a violation. So since that time, we have changed our procedures to require a courtesy letter be sent out informing that a complaint has been received alleging these types of violations, and we ask them to respond within a time. And then from that point, we can assess that particular activity and see if there's enough information to be able to issue a notice of violation.
Thank you. So in a case like this, where you received complaints that stated, I saw commercial activity, and the facts that they provided, it was noisy, a lot of people came, there was traffic on the street, people were dressed up. Would the planning department issue an NOV today based on facts like that, or would the planning department issue simply a courtesy letter?
We would have, I mean, today we would issue a courtesy letter and we would request again for information be submitted. Sometimes, a majority of the time, if it's an ongoing type activity, we'll ask for a site inspection. So that also helps us to determine if there is an actual violation notice. In this particular case, had that been done, I think it would have resulted in the same conclusion without the violation notice issue.
Great, thank you. One last question on this point. It sounds like Mr. Iser has established personal rules for the use of his property by his guests that essentially prohibit parties and gatherings. Does that personal rule translate into turning any party at the property into a planning violation?
No.
Thank you. Two last questions. Can the county regulate noise?
The county does not regulate noise. This falls under the Department of Health. I might add that it is a difficult violation to prove. There has to be sustained levels of noise for periods of time. And on this island, I'm not sure if they actually have inspectors. When this issue came up previously, the inspectors are actually on Oahu, which by that time, if the event is a single event, they can't get there enough. The other agency obviously is the police get called to if gets to a level that it's becoming a nuisance.
Thank you. That actually answered both of the questions I was going to ask. So I don't have any further questions for the director. Thank you.
All right. Aaron, do you have any cross examination? Go right ahead.
Good morning. So the question was to determine if it was private or commercial. So the information that's provided on Jason's website, did you receive any of that information from his websites?
I have everything that was part of the record.
Okay, so I think the only two parts of his record, and please, the question is going to be, did you receive anything else from him? Was the letter, it's landowner exhibit E and index page 31. And it was a letter from the person staying there. So I'm just going to say the bride. So landowner exhibit E or the index page 31.
Okay.
And then index page 32 was her transaction record. So those are the two things. And then the affidavits given by Jason, which is exhibit or index pages 29. Was that the only evidence that was submitted? I'm sorry, page 30. So index pages 30, 31, and 32. Jason's affidavit.
You never did finish your question, though.
Oh, ma'am, I'm trying to confirm, did he receive any other information other than these 3 documents?
I have everything that's in the record.
Okay. And that's the page before. Okay. So you only received those 3 items?
No, I have everything that's in the record.
Okay, because I didn't, anything else, oh, I'm just talking about the landowner's evidence. That it was just those 3 documents, Jason's affidavit, the bride's letter, and the bride's transaction receipt screenshot.
There is also landowner exhibits.
Yes,
Exhibit 1 is the letter from the outrigger.
but that was received after the decision was made. So the decision would, so the question is, when did the director make his decision when he issued the July 2nd, 2024 closure letter? And
The
the closure letter
information,
is in the record, page 33.
so the information that was provided to for the closure was the information that you had referred to, the items in the record under page 30 to, I believe, 32.
Right, so index pages 30, 31, and 32. That's what the director had to make his decision.
Correct.
Okay, and,
That wasn't the only thing they look at, though.
all right, yes, sir, so there were meetings at the planning department, or can you confirm the planning department met with Jason prior to the July 2nd closure letter?
I cannot confirm that. I'm not sure if they did. What I'm saying is that there was no sufficient evidence submitted to prove there was a commercial event.
Okay.
That is what's lacking.
Okay, and in the director's legal memo dated August 1st on page 4. So the planning director's legal memo.
I haven't.
It says that details of monetary transactions or other indices, sorry, I don't know how to say that word, of compensation or other supporting details. The question is, do you think we, the complainants, have that information?
I do not.
Okay. Is it in, do you believe it's in the director's discretion to ask the landowner for that information?
The information was provided to the landowner to either provide information that they did not do that particular type of event, or for us to find information that they did. Typically, we don't ask somebody that's received a complaint, can you give us information that you did this complaint? That's typically not what we do. Our job is to be able to look at it and determine a complaint has occurred or a violation has occurred. Our goal ultimately is to resolve it, whatever way that may be. We're not meant to be punitive. We're not meant to be the hammer.
All right, I'm going to stop you there. We'll just stick with the answer to the questions. Go ahead.
Okay, so you didn't have any, because we couldn't provide it and you didn't ask. And for Ms. Jean, she asked the question about, how do you determine if it's private or commercial? So if somebody makes a complaint, for example, they're conducting ATV tours, would you go and do an on-site visit to determine if there were ATV tours?
The object is to relevance for this particular event.
I'm going to let one question like that go. Well, overrule.
So the question, do I need to repeat it?
Just Yeah, go ahead.
Sure, I can answer that. So again, if we receive a complaint, we typically will send out a courtesy letter and request for a site inspection or information whether or not, they are not doing that particular activity. If it's an ongoing type activity and we show up and we see this particular violation occurring and they're not ceasing and desist based on the courtesy letter, we will issue a violation. Additionally, we look, as I mentioned, at any type of advertising. So these particular businesses typically advertise on the internet for these functions. Now, that's not to say they may not be a permitted use. They very well may be. They may not be in violation.
All right.
Okay, and I think I understand what you said. So if it was an ATV and they were advertising, you could see the advertisement, or you could request an on-site visit to see if there were ATV operations.
Correct.
Okay. Could that landowner say, you're not coming for an insight, I'm not allowing you to do an insight inspection?
Okay, this is irrelevant because it didn't happen in this case.
Right. So when your inspectors did some analysis, they didn't go to his websites where he advertises Kona Kai to see about he's advertising private chefs, in-home services that we've already discussed. Did they look at any of that, 2 restaurants?
They may have, but that wasn't the complaint. The complaint was that they were having a commercial event.
And so your opinion is that none of these amenities are considered commercial events?
No.
Okay.
If I might clarify.
Yes, sir.
Well, I don't think it's necessary. I think.
Okay.
And sir, you talked about the Department of Health. Do you know the 3 references for noise? Which I know the department doesn't enforce. I'm just trying to make a point. Do you know?
You make your point on your argument, okay? Let's not.
Are you aware of what the Department of Health's statute or ordinance is?
Yes.
Okay. Can you tell me what it is? What does it say?
Yeah, I'm gonna sustain that.
Okay. And then the police, they have 2 references.
Again, sustain.
Okay. And I guess I'll make it at the closing. What I'm just trying to say is.
No, you make it at the closing.
Jason does not have a special use permit. I believe he withdrew it.
Objection not relevant to today's proceeding.
Is that a
whatsoever.
question? Anyway,
Yeah, the question is, did he have a special use permit at that time?
Objection not relevant.
yeah, I'll allow an answer. Overruled.
As in regards to the activities and the property, there are currently no special permits.
Okay. All right. And so serving as a venue, and maybe that's what I should have asked, is a venue a commercial activity?
It can be, but there's a distinction between private and commercial.
And so then I'll follow up, with Ms. Jean asked, when you watched all those videos that we submitted, you believe that that was a private versus a commercial event, that the Kona Kai was not serving as a venue for a commercial event?
If I might clarify, the videos that I saw in the record were very difficult to see what was going on. All I saw was a complete black screen with a little light, and I heard coqui frogs and some noise. I had no idea really what the intention of the video was, other than to illustrate some noise that was occurring on a particular evening. In regards to determining whether an event is commercial or not, we have to find that link between there being a commercial type exchange or a ticket or advertising for an event, that kind of thing. We deal with this on a pretty regular basis with such things like outdoor concerts.
All
or
right,
things.
we'll stop. We've been on that ground before. Okay,
May I play a video and then I can ask?
we can try. Go ahead.
It's cross.
Yeah. Oh, yeah, it is. It
On
is
the
crossed.
slope.
You should have shown that through. Yeah, I'm sorry.
That's
You're absolutely right.
So
Yeah.
I just, okay, so we'll just confirm, because you all have watched the videos. The videos, you only really heard coqui frogs. You didn't hear any chanting or an MC.
We've established clearly that this county does not regulate noise.
Right,
All of it's regarding noise. Who regulates it? How much they're letting?
right. It's not relevant.
Okay.
You've got to let that sink in. The noise situation has been established. We
Right.
don't need to keep it up.
Okay, so all I'm trying to do is say a commercial activity. We talked about, doing an on-site visit, having the tickets to a concert. I'm saying that noise.
Are you saying, or are you asking a question? Because
I'm asking you, does noise, party noise, amplified noise, quick traffic, the statements from the 4 complainants, are any of those indicators of possible commercial activity serving as a venue for a party?
It's what we received as the complaint. And so we did our investigation. We could not establish that it was a commercial event.
Okay. And is there a reason that the department didn't meet with the complainants even though we requested to meet with the department?
I can't answer that.
Okay, and that's in the record.
Okay.
All right,
okay,
can you just give me, just so I can flip that?
Yeah.
I think that's it. Okay, so I have one last question for him. So I just want to confirm, sir, that when the director made his decision on July 2nd, he had a letter with no wedding date. He had an admission that she could not conduct an event on Jason's property. She made a statement about photos that was not.
this sounds argumentative. This is not.
Well, I'm just asking, this is all the evidence he had.
Yeah, asked and answered already. Too.
All right, so we'll confirm that. And then can you confirm the director determined all of our complaints were only allegations as stated in the director's legal memo? They were allegations and they.
The memo speaks for itself. So if that's in evidence, we don't need him to opine on
All right, thank you.
something that's in writing.
Okay. Thank you, I appreciate your time.
Thank you. Mr. Wong, do you have any questions?
Yes, I do. Mr. Darrow, real quick. You heard the testimony, you've reviewed the evidence, you're familiar with the record on appeal. Do you stand by your decision that there was no commercial activity that occurred on April 19, 2024, and ask this board to affirm that decision?
Well, it's April 19th, correct?
That's what he said.
Oh, I'm sorry. I heard.
That's exactly what I said.
I'm sorry.
I didn't.
Sorry.
Thank you. I don't have anything further.
Okay. All right. Well, we'll take, with no more witnesses, we'll take closing statements. Oh, I'm so sorry, Mr. Wong. Do you have any witnesses?
We do not, actually. Thank you.
Thank you. So everybody's whatever that word is. What is the word?
So have you closed your case? Have you rested?
Yeah, rested, thank you.
Okay.
Okay.
Yes, thank you.
All right, we'll take closing arguments. What are the time limits on that?
10 minutes as well.
10 minutes each? And we'll start with you, Larry. Oop.
Thank you. So Jason's advertising on his rental platforms, they definitely meet the cover your assets standard. And I know the planning department has worked with him on his advertisements. And his house and rules, they have all the right language. He talks about no parties, no events, the maximum guests, but he falls short in his enforcement of them. He says when he receives a complaint, he goes to the people who rented and resolves it either by fining them, stopping their visit, or other measures. That's all in his rules. He advertises commercial services such as rent-a-cars, personal trainers, massage, in-home services, and yet somehow his property is not considered a venue when there is amplified noise, traffic, and a gathering of more than one family and 4 additional unrelated persons, that somehow all of those advertisements and that information does not indicate that his Kona Kai property is serving as a venue, doing commercial activity. And on April 19th, he personally heard that amplified sound, and he saw his retreat, the Kona Kai, serve as a venue for a beautiful wedding reception. And it's really unclear, we're never going to know, if he upcharged his normal night when these folks were having the MC, the amplified music, the string lights. I have been told by a very reliable source that works with the county, in the county, that some vacation rental owners increase the nightly rent.
I'm gonna have to object to this line of closing argument. There's no foundation. Who is this reliable source? And it's beyond the scope.
I'll sustain that, but just remind everybody that the closing argument should deal with the evidence as presented, and it is only argument, it's not evidence. So we all know that it is argument, not evidence.
Right. That some vacation owners increase the nightly rate to cover these amenities such as a bouncy tent, fire knife performances, receptions, retreats, catering services, so the guests don't have to hire these merchants themselves. Similarly, they can provide the information, but their short-term vacation rental, or in our case, in this case, hosted rental, is serving as a venue. Jason provided these 3 documents that we saw, the bride's letter, his affidavit, and a transaction. It's disappointing that the county didn't ask for additional information or to clarify the bride's letter. As she points out, the dates in question, she doesn't even list the date. She points out that they took personal photos, but that was never mentioned in any of the complaints, so not sure why she wrote it. And also she states that she agreed to all these guidelines to limit on the property's use. But again, it appears she hired all these services and conducted her wedding reception there at the Kona Kai. And I completely understand that the county planning department does not, how do you say, enforce noise. And unfortunately, over the last year and a half, I'm intimately familiar with Hawaii revised statutes 342F, noise pollution, HRS 711-1102, unreasonable noise. And I know the police department is way overburdened with noise complaints. As stated previously, the Hawaii Department of Health does enforce Hawaii Administrative Rule 1146, but to clarify, that only covers stationary noise and equipment related to agriculture, construction, and industrial. They do not regulate people noise. Jason's noise monitors, which he has mentioned previously and are in his advertisements, they don't offer any relief to us because no action is ever taken, which I think is in that subpoena. And they offer little relief to us neighbors who are listening to Don't Worry, Be Happy at decibels similar to a Brew Block concert. And I do believe our planning department is overworked, and they are inspectors, not investigators. But I think these inspectors could have gone an extra mile and asked for some financial data for that night in question in order to determine was his property serving as a commercial venue for this wedding reception. And it's unfortunate that the planning department failed to meet with us for complainants when we asked to meet to go over our side. And we've all experienced these folks who they do what they want to do, even though their actions adversely affect each other, and they become increasingly emboldened when there's no enforcement. There's no reason for Jason to have a special permit, which he withdrew, because he's getting away with these activities. And we often cite the golden rule, do unto others as you would have done to you. There's also the silver rule, do not do to others what you don't want done to yourself. And as I stated before about the duck analogy, if it looks and walks and acts like a duck, it's a duck, similar to his property operating as a commercial venue. And what I don't want to have what happened over on Oahu in 2024, in which 3 ladies were killed due to lack of enforcement and skirting the law and rules by a suspect who was conducting unpermitted events at his property. The Silva Dome is well known for holding funerals, weddings, graduation parties, and concerts. And attorney Michael Green basically said, when you're doing something and no one enforces it, no one cares, you just do what you want. And State Representative
2-minute warning.
Gates says he was looking to the Department of Planning to explain what happened on the accountability. And in closing, regardless of the outcomes of this hearing, hopefully we've all learned some lessons. Ways to implement the Airbnb's fairness standard, which makes it possible for us to trust one another. And how to better implement the golden and silver rules. And like I said to Sage in the bathroom, I sincerely pray that there's a positive way forward. Because as I've told you before, I do want you to be successful in your business. But I'd like you to do that while respecting your neighbors, especially those who are most impacted. And to the board, I do appreciate your service to our great county of Hawaii. And I really appreciate everyone who took the time here today to be prepared. And I appreciate your patience. And I actually hope to never be here again, but thank you for your patience and your time.
Thank you. Thank you, Erin. Okay, County?
Good morning. It's still morning. Again, I'd like to reiterate, the scope of this case is very, very clear. The department did not receive any evidence of commercial activity other than the statement in 4 complaints that there was commercial activity on the property. A simple statement from a neighbor is not sufficient evidence for the government to take action against anyone. Lighting, traffic, people who are dressed up, and noise does not a commercial event make. The department does look at advertising, and Mr. Izard's advertising clearly shows, despite the sort of autofill material there from the hosting platforms, that he does not allow commercial events on his property. The department, just like when the police pull us over, the department has to assume that people are innocent until they're proven guilty. In this case, the department allowed Mr. Izard to come in and refute the information contained in these allegations that simply said it's a commercial activity, and it was loud. The vast bulk of what we heard today was about noise. And I don't think anybody is arguing that this was not a noisy party. Noisy parties are allowed, and the planning department doesn't have anything that they can do about it. If Mr. Izard has included personal rules that say no parties at my property, a party at his property is not a zoning violation. A party at my house is not a zoning violation until it becomes a commercial event. And we don't have any evidence that this was in fact a commercial event. Without sufficient evidence, the government cannot just go around citing people and fining people because their neighbors said so. It's as simple as that. And we can't regulate noise. And so the simple fact here is it almost doesn't matter what kind of evidence Mr. Izard presented to the planning department, because we first did not get over that initial hurdle that proved that there was a commercial event for him to refute in the first place. Whether or not the credit card statement had a date on it, whether it proved the day of the wedding, really not even relevant. What we need to prove first is that a commercial event took place. No, we simply do not have sufficient evidence that that was the fact. So I would ask this board once again to recognize the scope of your authority, which is to find that there was a violation, there was a clear error, there was an abuse of discretion, and I think it's very clear from our record that none of those things took place. So I would ask you to affirm the closure letter based on the evidence that you heard today. Thank you.
Thank you. Okay, Mr. Wong, landowner?
Thank you for your time today. I appreciate your presence. On behalf of Mr. Izard and Konakai, we ask that you affirm the director's decision that there was no finding and no violation for an unpermitted commercial event that did not occur. You heard a lot of argument, you heard a lot of heartfelt argument, but there's no factual basis to establish that there was any unpermitted commercial activity, period. Hence, the director's decision should be affirmed. He was not clearly erroneous in his findings, and this board should dispense with this appeal with an affirmation of the decision. Thank you.
All right, thank you. With that, the hearing is closed. And make sure here. So it is now the board's turn to deliberate. By that, I mean, we'll get a motion in one way or another and have discussion and make a decision. So I would entertain a motion.
Affirm or deny the director's decision.
It looks like
Board-
somebody's ready.
Board Member Rachel Abel, I move to affirm the county planning director's decision.
All right, we've got a motion. Has anybody second?
I would like to second that, John Kimura, board member.
Thank you, John. All right, we're open for discussion. Anybody have discussion?
I'm sorry, I would like some discussion. Ms. Abel, will you be able to make a statement or two supporting your motion?
My motion was based on the fact that on that date in question, April 19th, there was not significant substantial evidence to prove that there was a commercial activity occurring that event.
This is Terry Lewis. I have to agree with Ms. Abel. I know that the term commercial activity, we haven't received any kind of definitive statutory or regulatory definition, but I think the fact that there has to be an exchange of some kind of compensation in exchange for attendance at an activity or event is just has not been shown. We've just got innuendos and potential accusations, but we have no actual proof to work on for that. That's all I have to say.
The commercial activity seems to have occurred at the hotel where we have a transaction receipt, and that event was paid for. The noise complaint at the particular property in question appears to be a private party. So I don't see it as a commercial venue and in a commercial-based event.
All right. Do you want us to discuss?
Yeah, I do agree that it doesn't look like there was a commercial activity going on based on today's witnesses.
All right. So I guess we can call the question, correct? We'll take a roll call vote. Bethany, thank you.
On the motion to affirm the planning director's decision, board member Rachel Abel,
Aye.
board member John Kimura,
Aye.
board member Scott Martin,
Aye.
and Chair Kathy Lewis.
Aye.
Chair, you have unanimous, all ayes.
All right, thank you. Ms. Campbell, as you know, I would ask you to prepare a form to memorialize what we have decided for our consideration, and we'll take that up. I can't say for sure which meeting, can I? When we might take that up. Are we going forward with September's meeting?
No. So at this time, the next meeting that would be available would be October.
So probably we'll have it on the agenda for that. You can take a look. All the parties, anybody involved is welcome to observe what goes on. It's not a rehearing by any means. We're just taking a look what was prepared and maybe making some corrections or additions. But once we make our decision, our rules require that we can't change our mind. And even if we wanted to, but so that's what's going to be next. I guess we'd need that by August 29th, 2025, Ms. Campbell? No?
So Chair, if we want to go by our normal form of practice, generally
Oh, I'm sorry, yeah,
the form of the order would be 14 days.
sorry.
Presently, that date would be August 22, 2025. And we do allow for objections as a matter of practice. And objections would be 1 week later. So if either the appellant or the landowner has any objections to the form of the order, you can file that with the board on August 29th, 2025. The board will then review both and make their decision on what form to adopt at the next meeting that will be agendized. So right now, it looks like the soonest meeting would be in October. Okay? So that order would be findings of fact, conclusions of law, decision, and order. And I know Ms. Campbell is well aware of that form.
Okay, I do want to thank you most sincerely, Erin, for coming and preparing and having your witnesses. I appreciate the witnesses and the landowner's presence. And I know that you're probably disappointed with our decision as well, but hopefully we all will move forward in a positive way. But in the meantime, that's what we'll do next. Take it up in October. And with that, we'll move on then to the next case. If you guys want to take a minute to physically move out, well,
I'd like to send my personal blessings and thoughts and prayers for you and your husband as you go through these challenging
Yes.
times.
Yeah, that's tough times. I'm sorry that didn't work out. Okay.
Chair, do you want to take a 5-minute recess just to allow the parties to disassemble before we call the next matter?
I don't know. I think we can probably power through this and then be done in about 15
Okay.
minutes.
I will just note, it does appear as far as viewing the gallery, there are no other members of the public present.
Okay. All right. So the next item is Larry Rutkowski, planning number PLBOA-2025-000122. We're considering a defective petition, and we're appealing the decision of the planning director, date unknown, regarding commercial activity. The reason it's unknown is due to the defective position. The location of the alleged, the complaint is 524 Kalanicoa Street, Hilo, 96720. Bethany, are there any public testifiers on this agenda item?
No public testifiers for this, Chair.
Thank you. Has anybody appeared for this matter? I am noting for the record that the only people in the room other than the board and its staff are people from the last matter. And so it looks like the petitioner has failed to appear. And so I'll just ask if everybody here on the board has read the petition and the board's staff letter requesting additional information. Everybody aware? Okay, good. Since there's nobody here, we won't have any statements. And so at this point, I have to entertain a motion with regard to the propriety of the defective petition letter and dismissal.
I'd like to make a motion that the board finds that that it does not comply with the board rules and the petition can be dismissed. And this is with respect to PLBOA 2025-000122, Rutkowski.
Thank you, Scott. Martin, any second?
Rachel Abel, I'll second that motion.
Second that motion. Any discussion? All right, since the matter seems fairly straightforward without anybody appearing, we'll go ahead and take a roll call vote, I guess.
Scott, can I get you to just clarify your motion?
Okay.
Sorry.
Can you just restate your motion for the record?
Yeah, my motion was to, to dismiss the petition,
Finding it defective.
finding it defective. Thank you.
Thank you for that clarification. On that motion to dismiss, Board Member Scott Martin,
Aye.
Board Member Rachel Abel,
Aye.
Board Member John Kimura,
Aye.
and Chair Kathy Lewis.
Aye.
Chair, you have all ayes, a unanimous decision.
Okay, and we don't need any preparation of anything for that. That matter is concluded then, and the case will be dismissed. All right,
And-
now we're just moving on to approval of the July 11th, 2025 Board of Appeals hearing minutes.
I'm sorry, Chair.
Yes?
Before we move on, I'll just note for the record that since it's a board's motion, absent any parties, as the board's counsel, I'll draft the form of the order for the board and place that on the next agenda item.
I'm sorry, I missed that. Yes, thank you very much for doing that.
You're welcome.
Gotta have something, I guess.
Yeah.
Okay. All right, so has everybody had a chance to review the minutes from our last meeting? Very good. Everybody's saying they have. So I will entertain a motion to approve the minutes.
Rachel Abel, I'll move to make a motion to approve the minutes from July 11th, 2025.
Thank you.
Second.
Mr. Martin seconded. Any discussion? Okay, all those in favor, oh, well, let's do it that way. All those in favor, say aye. Aye. We're all in agreement?
Aye.
And it passes unanimously then. Okay, moving on to administrative matters. Ms. Wan, is there any status report for us?
We do not have any new movement. I will just note that Kai LLC, the board did receive the final judgment in order for that particular matter. The board's decision had been reversed in that particular case. That judgment has been uploaded to Epic. And so at this point, the matter concerning the board is concluded.
What case was that?
Kai LLC. It
What was
was
that
from
about?
2023. Yeah, it was a little while ago.
We didn't goof up, okay.
So, yeah, not for the members present today.
Yeah, not that anybody goofed up, I'm just teasing. Okay, any updates from staff? Bethany or Ashley, anything to let us know about? Okay, then anybody else have any announcements? Hearing nothing, I adjourn this meeting. Thank you, everybody.